basically taking everything Meg said as gospel, that everything she testified to has to be true because she says so. And we as the judges, we have to recognize, we have to acknowledge how tough it was for her to tell her truth on the stand. This rule does not apply, even though the court is saying it applies. Tory's team raises that specific argument, and all they say is, well, he's mistaken. And they don't actually address why he's mistaken. It holds that the Constitution is the highest, it is the supreme law of the land. And just because you say it doesn't involve the Confrontation Clause does not mean it does not. Well, if you're here, it's because you probably know by now that Tory Lanez has officially lost his appeal, meaning his 10-year conviction has been upheld. And as a criminal attorney myself, worked first as a prosecutor, now in criminal defense, I've seen a lot. And I'm very familiar with the facts and the law of this case. And I have to say that the only way I can describe this outcome is a complete miscarriage of justice. And I'm sorry, this video is going to be a little rambling. I'm not going to edit anything. I'm just going to get all my thoughts out there and break down the opinion with you. But as someone familiar with this case, I think the facts clearly justified a not guilty verdict. I think there were gaping holes of reasonable doubt all throughout this case. So that's with the trial itself. But now when you talk about the appeal, which does not deal with facts, it deals with the law and the application of the law to the trial to make sure everything was fair. I think there was at least one clearly flagrant violation of the law, specifically the Sixth Amendment and the Confrontation Clause, that where Tory has a right to confront his accusers. In this case, Kelsey Harris was one of the accusers. She was a witness for the state, and I don't think he had an adequate opportunity to confront her at all. But the judges here disagree, and judges obviously are smart people. So, but smart people can be wrong, and that's why what matters most is the analysis, the application of the law, and interpretation of constitutional principles, and to see if that's consistent with the precedent, with the history. And we're going to go through it together. So if you're new here, I've been making videos on pretty much every angle of this case. My name's Scotty O, aka the Gen Z attorney, and I've been around for a while covering the case. And it sucks that this is the end point we got to, but it still is worth talking about. It's not over yet. There is the possibility that the Supreme Court can step in and fix it. It's a very low possibility. I want to make it clear for everyone. It is a low possibility, but it is a possibility nonetheless. So that, and the other thing I want to say before jumping into the opinion is to all of our friends over on Team Meg who were awfully quiet, awfully silent for the last 3 years that this case has been pending. I've had a couple in my comments, a couple over on X that have been my consistent haters that have been telling me that I'm wrong about everything. So they've been there and they get credit for being loud and proud, even if they were wrong. But there's been a lot that have just come out of nowhere, come out of the woodworks, come out of thin air, that are now gloating loud and proud about this case because they feel like they got the right outcome, the right conclusion, but they have no idea why. And I can guarantee you that's the case, because I can press any single one of you people on Team Meg that's celebrating this decision. I can press any single one of you on the facts of the case. I can press you on the law as applied. I guarantee you would crumble, but you would still not change your mind, which says a lot about, I think, our discourses. Doesn't matter what evidence you're presented with, your mind will still not be changed. But that aside, so I just find that really funny that there's a lot of people feel awful bold now to be loud and proud. And it's just especially funny because, yes, you're right in saying that the verdict is what it is, the outcome is what it is, that Tory lost, but you have just no clue the first reason why that is, other than your fifis, meaning your feels, that you just feel like this is the right outcome, even if it was completely unsupported by the facts and the law. So open invitation to any one of you who wants to get completely pressed, completely destroyed on the facts and the law. We'll probably do actually a live debate space coming up through a YouTube live stream as well as a Twitter Spaces, just so we can have an open invite for all these people who want to get checked real quick. Yeah, so stay tuned for that. But that aside, I've been yapping enough as a preamble. Let's jump into this opinion. So I'm not going to go through the entire thing. The main thing I want to cover is going to be the facts as the judges summarize it, because you can learn a lot from how the judges view a case based on how they frame the facts of the case. So I'm gonna start with that, and then I really just want to touch on the Confrontation Clause issue and probably have that be it for the video, because as you can see, it's a 46-page opinion. I can make another video where I go through the whole thing, but for this video at least, I want to cover the big ticket items with you guys. So All right. In December 2022, a jury convicted Daystar Peterson of assault with a semi-automatic firearm on Meg and Pete, carrying a concealed unregistered firearm in a vehicle, and discharging a firearm with gross negligence. Court sentenced Peterson to 10 years in the state prison. On appeal, Peterson contends the trial court committed a number of errors. We find no prejudicial error and accordingly affirm Peterson's conviction. I'll highlight that to start. Because I did talk about this on my appeal video when I was talking about what kind of happens with an appeal. I mentioned a little earlier, appeals have to do with law and not facts. I think the facts of this case are really strong for Tory Lanez. Like I said, tons of reasonable doubt all over this case. But what we're dealing with here is the application of the law. And specifically, were there any violations of law that were harmful enough to actually affect the outcome of the case? And this line here is kind of the key. We find no prejudicial error because the doctrine is called the harmless error doctrine, which basically says even if there was an error in the case, a bad application of the law, if it was harmless, meaning it did not actually alter the outcome of the case, then we're not going to allow it to change the outcome. And so that's what this language here is referring to when it says we find no prejudicial error, meaning even if there were errors, none was big enough to cause enough prejudice to jeopardize the outcome of the case. So I want to point that out because this is not them saying there were no errors. This is, in fact, could very well be an admission that there were errors, but the court just finds that there was no error, no single error strong enough, or the combination of all errors was not strong enough to change the outcome of the conviction. So. All right, facts and procedural background. Peterson fires 5 shots at Pete, striking her in the feet. On July 12, 2020, Pete went to a gathering at Kylie Jenner's house. At some point, Pete texted Peterson and told him to come. When Peterson arrived, it was really late. Eventually, Pete wanted to leave. Pete, her friend and personal assistant, Kelsey Harris, and Peterson got into an SUV driven by Peterson's driver, Jaquan Smith. An argument started about the relationships among Pete, Harris, and Peterson. I think so far that's accurate. Yeah, I think that's an accurate summation so far of kind of the lead up to the events and who introducing our characters being Megan Thee Stallion, Tory Lanez, Kelsey Harris, and Jaquan Smith. Pete asked to be let out of the SUV. Pete got out and started walking away. She heard Peterson say, "Dance, bitch." Pete turned her head a little bit and saw Peterson pointing a gun at her. She froze. Pete heard shots. She looked down at her feet and saw all the blood. Now, this was a good setup. However, I will go back and note, simply saying an argument started about the relationships among Pete, Harris, and Peterson, and then going into completely just accepting Megan Thee Stallion's version of events here, you can already see they're buying into the framing that basically taking everything Meg said as gospel, that everything she testified to has to be true because she says so. And obviously, from our position, we're pointing to Meg, and I know like the Milagro trial is going on right now, and she got sued for defamation for saying Meg lied during the trial, but here I am going to say it out loud. Meg lied during the trial. I feel like I can confidently state that about when we look at her recollection of what happened that night. Because even if it's a lie by omission, it still is a lie. When we talk about, did Meg talk about her fighting Kelsey? Did Meg talk about the nature of the disagreement here? And the fact that the disagreement started because Tory revealed that he was sleeping with both Meg and Kelsey. And that did not start an argument between Meg and Tory. That started an argument between Meg and Kelsey, which turned into a physical fight. And that's not just me saying that based on my own fifis. That's based on the injuries that Kelsey sustained, specifically the scratch marks on her, the broken nail on her, the clumps of hair that were missing from her, the broken strap on her bathing suit. She was clearly assaulted. And specifically when you look at the scratch marks, has anyone seen Megan Thee Stallion's nails on a consistent basis? Those things could cut for real. So it's not just, it's the forensic evidence of the injuries on Kelsey. It's also the testimony of the neighbor, Sean Kelly, who specifically testified seeing the 2 girls that were fighting and that before seeing Tory get out of the car. So it's pretty conclusive, I would say, that the girlies were fighting. And the fact here that we already have the judges leading off by granting Meg's framing of the story just as complete fact is, I think, very telling as to the how the judges are approaching this case. All right. Pete dropped to the ground and crawled into a driveway. Pete felt pain in both her feet. After that, it got blurry. Pete saw Peterson and Harris walking toward her. Peterson started apologizing. Pete got back into the SUV. They heard police sirens, and Peterson told Pete and Harris, "Please, y'all, don't say anything. I'm about to sign a big deal. I'll give both of you $1 million each." At 4, we'll come back to that. At 4:27 a.m., Harris sent a text to Justin Edison, who handled Pete's security. Text said, "Help, Tory shot Meg, 911." All right, the bribe claim. Once again, the only person who testified to there being a claim of bribery was Meg. Because guess who said there was no bribery at all? Was Kelsey. And Kelsey, and we're going to get a lot into Kelsey's testimony later, and her time on the stand, but and how uncooperative she was, and she was not answering questions. You know what one of the few questions she actually did answer was asked when she was asked whether or not Tory bribed her. She emphatically stated, "Absolutely not. He did not bribe me." So once again, even taking the light most charitable to Meg's side of the story and with how things went down at trial, at the very least, you have conflicting testimony there over whether or not Tory said this statement. "Please, y'all don't say anything. I'm about to sign a big deal. I'll give both of you $1 million each." Conflicting testimony because Kelsey denies vehemently that was said. But here we have the court, here we have the judges that are just accepting what Meg states as truth, as gospel. And I think that's wrong. But nevertheless, we continue on. Police stopped the SUV. They asked everyone to get out. Pete told the police she'd stepped on glass. She didn't tell them she'd been shot. When asked at trial why she told the police she'd stepped on glass, Pete referred to the then recent murder of George Floyd. Pete testified she didn't know if they were going to shoot first and ask questions later, and she didn't feel safe with the police officers. I can buy that. I can understand all that. Officers found a 9mm Luger semi-automatic handgun on the floorboard of the front passenger seat. The gun was in the slide lock position, meaning all the rounds had been fired from the magazine. It was warm to the touch, even though it was cold outside at that hour of the morning. Officers also found a bloody towel in the back seat. Once again, this is good summation, good summaries of the facts. Because now we're talking about officers, right? This is officer testimony establishing just what they encountered at the scene. We're past the subjective retelling of what Meg is recalling from her own self-serving state of mind. Now we're into what the officers are finding, which is going to be more reliable as them not having a dog in this fight. Officers took Peterson, Harrison, Smith into custody. At the station, officers checked the hands of all three for gunshot residue. The samples taken from Peterson and Harris were positive for gunshot residue. Okay, glad they included that, because that's what a lot of Team Meg folks seem to like to forget, that yes, Tory had gunshot residue on his hand, but so did Kelsey. And let's remember, who got their DNA tested on the gun? Oh, it was only Tory. Kelsey never had her DNA tested, or the prosecutors never tested Kelsey's DNA. Of course, she wasn't going to do it herself. The prosecutors never tested her DNA to see if her DNA matched any of the profiles on the gun. Huh. Curious. Almost like you can't prove beyond a reasonable doubt that Tory was the one that shot the gun. But that aside, that's the facts of the case. This video is mainly about the law. A criminalist testified at trial that if Harris had been standing within feet of an individual firing a firearm and came into contact with that individual after he fired a firearm, she would not be surprised if Harris tested positive for gunshot residue. No gunshot residue particles were detected on the sample taken from Smith. Okay, so you've got the state's expert who's going to testify. Now, where's the defense expert? Where's the defense expert who's going to give you the counterpoint? We're only going to accept one side of the story? That's, once again, we're just accepting the framing of the state. But even then, even accepting the most charitable version of this, which is what the state's theory of things, we're talking about Kelsey still had to be within feet of an individual firing the firearm, which, for anyone who knows anything about gunshot residue, it does not, it goes forward in the direction of the bullet and also ejects out the slide cartridge. So if Tory really shot the gun the way he did, where he was leaning outside of the car and had the gun extended outside of the vehicle, the gunshot residue would go forward out of the vehicle and sideways out of the vehicle. It would not go back into the vehicle, but certainly would not go into the back left seat, because that's where Kelsey was. Is that right? Under Meg's theory? Because if Meg got out from the right side and walked forward, that would mean Kelsey would have to have been on the left side. But that aside, right, she has to have been, at the very best, the very most best case scenario for Meg and the state and the prosecutors here, Kelsey had to have been within feet of an individual firing the firearm and came in contact after firing the firearm. But how is this anywhere at all consistent with Meg's testimony? It's just simply not. So that's why I'm comfortable calling Meg. I think she lied on the stand. Maybe it wasn't intentionally lying. Like, I know what I'm saying is wrong, but I'm going to say it anyway. But she said untrue statements that do not reflect the reality on the ground. All right. An ambulance took Pete to the hospital. Neither in the ambulance nor at the hospital did Pete tell the medical providers that she'd been shot. She later explained, in the black community, it's not really acceptable to be cooperating with police officers. Pete also said that when a woman accuses a man of something, people have a hard time believing you. She added, this whole situation in the industry, like a big boys club, like I'm telling all of y'all's friends and now everybody about to hate me. That's an interesting point because I can certainly see why she would say that if that was her subjective belief. That, oh my gosh, if she says her truth and says what really happened and accuses a man of something, no one's going to believe her. And if she cooperates with the police, then she's going to lose her black card and not be seen as really pro-black anymore. Well, guess what? She ended up cooperating with police fully, and she ended up accusing Tory of shooting her. The two things that she said she was scared to do because, she didn't want to cross the industry or the boys club. Yet what's happened in the 5 years since then? Her career has exponentially multiplied in popularity. So either what she's saying is not true, what she's saying is she was misunderstanding how things really work, or maybe she was just underestimating her own star power that she can rely on, because she certainly did rely on that for this case. Or maybe she's underestimating Roc Nation's power as her label that was able to protect her and shield her throughout this whole thing. I don't know, but that's just an interesting observation that she ended up doing the exact two things she said she was scared to do because it would cost her career. And look what happened. Her career has exponentially multiplied. Around 9:05 the morning of the shooting, Peterson called Harris from jail. A recording of the call was played for the jury. Harris told Peterson that Pete was still in the hospital and she was waiting outside. Peterson said, I know so this is Tory saying to Kelsey, calling Kelsey from jail. Tory says, I know she's probably never ever gonna ever talk to me ever again, but bruh, I just want you to know, bruh, N-word, I was just so fucking drunk. I never do some shit like that, bruh. You know, regardless, that's not gonna make anything right, and that's not gonna make my actions right, bro. But I'm just deeply sorry, bruh. So like, I feel crazy, bruh, but made a mistake. Like, what happened already, bruh. Can't take it back, bruh. I'm just telling y'all, I'm sorry, bruh. How many bruhs was that? It was like double-digit bruhs. And I will say, this is certainly, I would probably say this is the strongest piece of evidence for the state. Because certainly I think the most reasonable way, the most logical way of reading this is an admission to the shooting. So I'm not going to, people seem to think I'm like some delusional hardcore conspiracy theorist that is just, there is zero evidence to convict Tory with. No, I've never said that. You can go back to my videos back in 2022, my first ever videos I made on this. My stance was not that Tory was innocent. My stance was Tory was not guilty. And there's a difference because innocent means they didn't do it 100% point blank period. Not guilty means it doesn't matter whether they did it or not. You don't have enough evidence to prove that they did it beyond a reasonable doubt. And that's an important distinction to make because, right, there is evidence here that does support a conviction. Does it go to the level of beyond a reasonable doubt? Absolutely not. But that's where the jury and I disagree, I suppose. But yeah, this confession, this admission certainly comes off as an admission to shooting. I know his explanation was that it was an admission to sleeping with the both of them and that he regrets that. Maybe that's true. I think at first glance, I think the more likely explanation is the shooting. But that if it's like a 60-40, that still means there's a 40% chance it was not. And that's not nothing. But either way, 8:59 p.m. that evening, Peterson texted Pete. So that's Tory texting Meg. Text said, Meg, I know you're probably never going to talk to me again, but I genuinely want you to know I'm sorry from the bottom of my heart, and I was just too drunk. Nonetheless, shit could have never happened, and I can't change what I did. I just feel horrible because I genuinely just got too drunk. I love you, and I hope you're okay. Once again, these two together were the strongest arguments, the silver bullets that probably sunk Tory, would be my guess. Peterson sent Pete other text messages just apologizing. Pete had bullet fragments in both of her feet. She had to have surgery and physical therapy. Pete couldn't walk for a while. She can't really feel the left side of her foot. About 4 days after the shooting, Pete told police who had shot her. Pete testified she'd had a change of heart because Peterson had tried to start getting ahead of the story online. He'd put it on a bunch of different narratives about what happened. DNA testing of the Luger revealed a profile of at least 4 people. Peterson could not be excluded or included. His contribution was inconclusive. DNA testing of the magazine also revealed a profile of at least four people. Peterson was not one of them. No usable fingerprints were found on the gun or the magazine. Okay. I like how they did that right there. Real slick-like, saying that first off, they lead with the one where he's inconclusive. Because, once again, this is why I said we read the facts, because it reveals a lot about how the judges are approaching the case, and you can kind of intuit to their conclusion based on how they frame the facts. So just the very fact that they're leading with the stronger DNA evidence, which even then, when you actually look at the DNA breakdown, his inconclusivity, if that's even a word, the fact that he was inconclusive on the gun doesn't just mean it's like, oh, well, it's a 50-50 and we just really don't know. No, the inconclusive means it was like less than a 0.01% chance, or less than a 0.1% chance, but because it was not zero, because there was some chance, even though it was less than 1%, oh, well, we have to say it's inconclusive. So they start with the inconclusive one, and they frame it that way. They don't even bring up the actual numbers there. They just say, oh, it was just inconclusive. And that was for the gun itself. But then you look at the magazine, DNA testing of the magazine also revealed a profile of at least 4 people. Peterson was not one of them, meaning he was excluded. But they don't say that. They don't want to use that word. They knew the right words to use up here, saying, well, he couldn't be excluded or included. But then when you come to the part where he was actually excluded, they just say he was not one of them. So it's like they're leaving out the terms of art that support Tory, that frame his argument in a stronger way, and I can't help but feel like it's intentional based on the conclusion that they reached. But regardless of that, in response to the prosecutor's questions at trial, Pete testified she was having a really difficult time sitting up there and trying to comfortably tell her story. Apparently referring to spectators in the courtroom, Pete said a group of people had been continuously spreading misinformation to make her look like a bad person. What is that? I don't know. What's the relevance of this at all? I don't know how this is relevant at all to the case and whether the law was correctly applied. This is just a complete, playing to, oh, poor Meg, victim Meg, how sad, it's so tough for her, and we as the judges, we have to recognize, we have to acknowledge how tough it was for her to tell her truth on the stand. Was it hard for her to sit up there in front of all those people and say her story? Yeah, I'm sure it was. But do you have to point that out during your legal opinion, discussing the law of the case? What relevance does that have at all, other than, once again, to reveal the bias here, the bias towards Meg? And just to be clear, I'm not implying that there's any sort of corrupt conspiracy going on. I've not seen any evidence of that. If people want to send me stuff to look at, I'm happy to look at it. I know obviously there's been a lot of questions over the influence that companies like Rock Nation have on and had on this case and have on current cases that are pending. I know a lot of people feel that way. I'm always an evidence first guy. Like, show me the facts, show me the evidence, and then I'll make my opinion. But so yeah, I'm not implying there's some corrupt conspiracy here. I am explicit. I don't have to implicitly say this. I will explicitly say that the judges do have a bias towards Meg and saw her as a sympathetic victim of a heinous crime here. So I think that's pretty clear from how they retell the facts. The fact that they adopted her entire story, basically word for word, and they're including stuff that's completely irrelevant to the legal opinion. But anyway, all right. Getting into the procedural history, what he was charged with, what he was convicted on. Okay, we talked about the trial. We talk about Sean Kelly. The only thing I'll point out is that Sean Kelly was the neighbor, the witness who testified. The only truly independent witness from the 4 people in the car who testified. What I'll point out is that he heard loud arguing, looked through his window and saw 2 girls arguing. Then they started fighting and they were pulling hair and hitting each other, and it was quite violent. And that a tall man got out of the driver's side of the car and got involved in the girls fighting. That would have to be Jaquan Smith, the bodyguard. And then, oh, what do we have here? One of the girls went to the car. Kelly, the neighbor, then heard what at first he thought were fireworks. He saw a muzzle flash. At about the same time, a smaller gentleman got out of the back passenger seat. He was shouting a lot. Kelly saw more flashes and what was obviously gunfire. Muzzle flash was near the girls. Kelly did not hear anyone say dance bitch, although both defense counsel's questions and Kelly's answers were unclear. Kelly seemed to say the girl, who was the aggressor, went to the car and he saw the muzzle flashes coming from her hand. Kelly then said the flashes came from the shorter man. Kelly testified, I believe I saw the girl shoot first. They were both shooting. Kelly never saw a gun. He called 911. So yeah, I want to include that. Credit to the court for including Sean Kelly's testimony in its entirety. Talk about a great litmus test for people's bias when they're looking at this case. You get the Team Meg folks that point to Sean Kelly's testimony where he was saying that he saw the little man shooting all over the place. And like, look, he said he saw Tory shooting. And then you get the Team Tory who is saying that, pointing to the other part of Sean Kelly's testimony where he says that the shooting started with the girls. Well, the first that the girls were fighting, and then the shooting started between the girls, and then the guys got involved. Yeah, it's a good Rorschach test. If you're the enlightened centrist like I am, the enlightened fence sitter who sees the truth, I see the matrix for what it is. I point to his testimony and say, wow, that sounds completely inconsistent. Like both of those things cannot be true. There could not have been two guns. There was only one gun. But it does support what the facts we know now, which is Bradley James's testimony, where he overheard Kelsey state during the trial, during one of the breaks, that she shot the gun, and then Tory went and wrestled the gun away from her, and more shots were fired as he was wrestling it away from her. That combined with Jaquan Smith's testimony, or that he did not testify at the trial, but now after the trial, he's corroborated that same story. That makes a lot more sense of what actually happened here, which is that Kelsey had the gun, and then Tory went and wrestled it away from her, which completely explains why they both had gunshot residue on them, why why the gunshots came out at the frequency that they did. I'm forgetting now if it was 3 then 2 or 2 then 3. I think it was 3 shots, pause, 2 shots. Yeah, that is what it is actually now that I'm thinking about it. That Kelsey shoots the 3 shots, and then as Tory goes to wrestle the gun away, there's the pause, and then as he's pulling it away, there's 2 more shots. I think that completely explains what happened here and gives us the clearest picture possible. But either way, all that aside, Sean Kelly's testimony completely destroys Meg's theory of the case and her recollection of what happened that night. With her, she just got out and she was just walking away, and then she just heard Tory behind her just yell, "Dance, bitch!" and then shot at her feet. No, that's all it was. No. Obviously, what happened was the girls were fighting, and then the gun got involved between the girls, and then Tory got involved to try and get the gun away. So, yeah, that all comes from Sean Kelly's testimony. But either way, moving on. All right, on cross-exam, Kelly admitted he told investigators that the short guy came out of the car, and then he shot the girl. So yeah, now we're getting into his testimony of Tory being the one doing shooting as well. Peterson chose not to testify. True, Tory did not testify. Jury convicted him on all 3 counts. Then we get into sentencing. That's kind of it, I think. Yeah, just more sentencing stuff. Not really going to talk about that today. I could come back and do another video on it, and I'm already going for a while. Gosh, 27 minutes. I want to get into the actual legal analysis now, specifically of the confrontation clause. Let's see if I can find it. I think I'm getting close. Nope, I think it's the next one. Nope, just kidding. One more. And yes, here it is. The trial court did not err in permitting the prosecution to play for the jury as a prior inconsistent statement the recording of Kelsey Harris's interview with prosecutors. So, once again, just the quick recap. We're dealing with an appeal, which the appeal does not actually address the issues of fact. The jury is the finder of fact. They determine what happened factually. And once they've made their finding, that's it. That's the truth, as far as how the court is going to view the case. With that said, though, they still can be overturned if they're clearly erroneous with their findings of fact, but that's a completely insanely high bar, and that's not what happened here. So now here we are in appeal. dealing with were there any legal violations, meaning constitutional violations against Tory that happened during the trial. I made my whole video predicting the outcome of the appeal, and my main argument that I hung my hat on was this argument that the court violated the confrontation clause, the judge violated the confrontation clause, and doing so was a reversible error, and thus the case should be remanded back down for a new trial. And the basis for that was this idea that I'm sure we'll get into the facts here, but that Kelsey, so who was there that night and was part of the fight, and according to witness testimony was the one who started with the shooting, she testified at the trial. She was called by the state because the state believes they knew what she was going to say, which was that she was going to corroborate Meg's entire story, that Tory was the shooter. The only problem was that once she started testifying, she started saying stuff like, I don't know, I don't recall, I was drunk, it was a blur, and even saying, I plead the fifth. I plead the fifth, meaning if I answer this question truthfully, I might be incriminating myself criminally. The answer I give you might prove or might be used against me as evidence that I committed a crime. So she pled the fifth several times during her testimony. This was a complete curveball for both the prosecutors and the defense because the prosecutors were expecting her to corroborate Meg's story. So how did they respond to this uncooperation from Kelsey? Well, they did so by playing a prior interview that she gave to the prosecutors, a recorded interview. They ended up making a motion to the judge to have that played to the jury and have that basically used as substantive evidence of this is her testimony, here's what she's saying. Here's her testimony of what happened that night, under oath, sworn, all that good stuff. That, to me, is a violation of the confrontation clause because Tory Lanez had no opportunity to confront his accuser in this instance. Like, yes, Kelsey Harris was on the stand and he could physically confront her, but part of the confrontation clause, I'll get into the full nerdy breakdown as I break down the actual analysis that the court does here, but the confrontation clause allows you two things. It allows you to know who your accusers are, and it allows you to confront them in court by way of cross-examination, meaning you can ask them questions, you can lead them, you can impeach them during their testimony to try and prove they're biased, they're not credible, they're inconsistent. That's all part of the confrontation clause. Now, certainly, yeah, there are exceptions to the confrontation clause, as there are exceptions to everything, but none of those were applicable here. And the reason why I say strongly, and I still believe, that the confrontation clause was violated here was because Kelsey's prior interview, Tory had no involvement with. He was not there. His lawyers were not there. No one was. I don't even think it was a sworn interview. It was a voluntary statement that Kelsey gave to police and to prosecutors that was recorded, not under oath, not sworn, and with Tory not there. That means he had no opportunity to ask her questions, to cross-examine her testimony from that video. You can't cross-examine a screen. Just like I'm speaking to you right now through a screen, you guys can't stop and ask me questions about what I'm saying right now because it's a pre-recorded statement that I'm making. We can get into it in the live debate that I'm going to set up soon, but yeah, it's you can't cross-examine a screen, and so that's the issue here, and that's what I was saying strongly, that Tory Lanez's right to confront Kelsey as a witness against him was completely, flagrantly violated and justifies a new trial where either she testifies or she doesn't. But if she doesn't testify or you can't get her to testify, then that video does not come in as substantive evidence at all. So, all right, let's read it. Trial court did not err, so they're saying there was not even that there wasn't even a harmless error. They're just saying they did not err at all in permitting the prosecution to play for the jury as a prior inconsistent statement. So this is going to be our big fact here, our big legal term of art, prior inconsistent statement. I want y'all to remember that. The recording of Kelsey Harris's interview with prosecutors. All right. Peterson contends the trial court reversibly erred in permitting the prosecution to play for the jury its recorded interview with Kelsey Harris. Peterson relies on the confrontation clause in Crawford versus Washington, 2004. This is a big case. This gives us our test for how the confrontation clause is met in a case. And we're going to get into that exactly. And yeah, confrontation clause comes from the Sixth Amendment to the U.S. Constitution. All right, Peterson is mistaken. Oh boy, let's see why. The issue is one of admissibility under the evidence code. It does not involve the confrontation clause. Wait, how does that make any sense? How can this reading, my reading of this, what I'm getting from my reading of this is that this does not involve confrontation clause. This is purely a question of evidence and whether evidence is admissible. Well, guess what? If you admit evidence that violates the confrontation clause, then you violated the confrontation clause. Like, that's duh. That seems self-explanatory. But so already I don't really know where we're going. But let's keep reading. The prosecution subpoenaed Harris to testify at trial. The court had appointed counsel for Harris, and the prosecution had granted her use immunity, meaning that anything she said was not going to be held against her. Which that by itself, that's a whole other can of worms to get into. But yeah, once on the stand, to say Harris was a reluctant witness is an understatement. That part is true. Harris repeatedly claimed not to remember what had happened that early morning and in the days following the shooting. To question after question, Harris replied she didn't remember, couldn't remember, or didn't know. She repeatedly said it was a blur. Several times, Harris said she wanted to take the fifth. The court told her that she had to answer the questions. Harris repeatedly said, I don't want to be here. So, yeah, she was trying to take the fifth. Court told her she had to answer questions because she was immune. She was granted use immunity, meaning she could not be prosecuted for anything she said, meaning she has no Fifth Amendment privilege anymore, because even if she says something, she could admit that she murdered somebody on the stand in a completely unrelated case, and that my understanding of that is that could not be used against her. But maybe that's too crazy. Let's just focus it in on the case. She could fully admit that she was the one that took the gun and shot at Meg in this case, but the use immunity means she wouldn't be prosecuted for it. So taking the fifth doesn't really apply, even though she tried to. All right. In an attempt to refresh Harris's recollection, the prosecutor played excerpts of a recording of a September 14, 2022 interview. The two prosecutors had interviewed Harris in the presence of her husband and an investigator from the DA's office. Two attorneys representing Harris were present on the phone. Again and again at trial, Harris told prosecutor she'd have to refresh her recollection with the recording. Confronted with her prior inconsistent statements, Harris testified that there were some things she just wasn't being truthful about in her interview. All right, that's a lot to take in. First things first, refreshing recollection. My understanding of refreshing a recollection, you don't do that in front of a jury because that's testimonial. You're effectively testifying at that point with the thing you're using to refresh recollection. I'll tell you the classic example that I use I use as a prosecutor for refreshing recollection. So I'd be prosecuting somebody, we'd be in trial, I'd have my police officer testifying, and the officer, let's say, forgets a detail, or he gets a detail wrong. And I know that because I have his incident report right in front of me, and I'm kind of following along with him as he's testifying. So he gets something wrong. The first step I would do as a prosecutor is say, are you sure about said detail? So let's say, just to ground it in a concrete example. Officer's testifying, and he says, I pulled him over, and it was rainy that night. And I know from the report, it was not. He reported it was not rainy that night. I can say, are you sure it was rainy that night? And that's kind of the cue to be like, for the officer to think about it. And usually they'll catch and be like, oh, no, actually, no, it was not raining that night. And then, boom, we move on with the testimony. But let's say he doesn't correct it. He says, it was raining that night. I know that's wrong from the report. I say, are you sure it was raining that night? And he says, yes, I'm positive. I could then say, Your Honor, may I approach even before getting to that, I would say, would reviewing your report refresh your recollection on whether or not it was raining that night? He could say, yes. I could say, Your Honor, I'd like to approach the witness to show him his report and refresh his recollection. Judge would say, please approach. I'd give him the report. I'd say, Mr. Officer, please read this report, and when you have sufficiently refreshed your recollection, please look up to let me know you're done. He would do that. He would look up. I would then ask him again, Officer, to your recollection, was it raining that night? And he would say no. That's the way you refresh recollection. What I don't do is I stand up in front of the jury and put the report on the projector and point to the part where it says it was raining and say, Officer, does this refresh your recollection that it was not raining that night? No, that's not what you do, because you're not, at that point, the report, which is hearsay, is testifying to the jury. And hearsay, by the way, is any out-of-court statement offered for the truth of the matter asserted, meaning for the substantive truth of the issue. and officers report, that's hearsay. And Kelsey's interview, her video here, that is all hearsay. Everything she said in that video, because it was out of court, and it was being offered for the truth of what happened that night. So that's refreshing recollection. So already right out the gate, the prosecutors here, by playing the video to the jury, if they want to take her in chambers or just even have her sit there, but wear headphones and listen back to her statement from the video, and then ask her if her recollection has been refreshed. So that's the way that I would imagine this would be done. That would be constitutional. So already right out the gate, we're not refreshing recollection in a way that I find to be constitutional. That's the first part. Second part, let's look at the cast of characters that were there for this. The two prosecutors, Kelsey, her husband, an investigator from the DA's office, so another prosecutor, or someone with the prosecutors, and then Kelsey's two attorneys. Pop quiz class. Can anyone name Tory Lanez in this list? Can anyone identify Tory Lanez's attorney in this list? Oh, you can't, because they weren't there, because it was only Kelsey and the DA's office and her attorneys. It was the DA's office, Kelsey, her attorneys, and an investigator from the DA's office. So no one from the defense was here and able to question her or cross-examine her. On top of that, I still don't think it was sworn. I don't think anything she said in the interview was under oath. It was just to get her testimony or get on in a recording what they expected her to testify about, so that way they'd be prepared for it. So yeah, a lot to take away from just that paragraph there. All right, confronted with her prior inconsistent statements, Harris testified there were some things she just wasn't being truthful about. So she's acknowledging that she was lying in her interview. So once again, now we're playing a video for the jury that she's saying now under oath in court. She's saying, I was lying in that interview. I was not being truthful in that interview. So that, and even here, using the term prior inconsistent statements, I don't even know if that really applies here, because a prior inconsistent statement, I'm not sure that you can just say, I don't know, and then hold up a prior statement of her where she's talking as if she does know and say, aha, look, inconsistency. Usually inconsistency has to mean something that's in contradiction with itself, or the statements are contradicting each other. Like I said earlier, was it raining versus it was raining versus it was not raining. Those statements are inconsistent with each other. Those are contradictory. Just saying during the course of the trial, I don't recall or I don't know, and then playing a prior statement where she does purport to know, I don't even know if that's technically the proper application of this language, prior inconsistent statement. But either way, Harris also testified she didn't remember telling prosecutors things that she can be heard saying in the recording. When asked if she had said in the interview that she'd seen Peterson shooting through the window into the top of the door, Harris replied, again, this is the night of alcohol. I don't know. Okay, just more saying Kelsey is saying she doesn't know. All right, we're getting into some law now. In light of Harris's claimed failure to recall what she'd told the authorities and her testimony that she had been untruthful in some of her statements, the prosecution proposed to play the recorded interview for the jury. Citing Evidence Code Section 770 and 1235, court said it would allow that. Section 770, let's break these down one at a time. 770 generally governs the admissibility of extrinsic evidence of a witness's prior inconsistent statement for impeachment. Okay, this is legally sound as far as impeachment goes. You can impeach a witness who is saying one thing at trial, but you have evidence so you can prove they said something else outside of trial. You can use that out-of-court statement to impeach their in-court statement. I don't have an issue with that. You run into some trouble of where are you crossing the line now between the prior statement is now being treated as a substitute for testimony. That's where you go too far as far as, once again, getting into this confrontation clause issue, because the cross-exam is just of the utmost importance. And whatever is being treated as the substantive testimony, the substantive truth of what happened, that's what needs to be cross-examined, or at least able to be cross-examined. So if it's just for impeachment, though, this is just saying that this witness is not credible, then that's one thing. Because, yeah, if the state's only goal here was to have Kelsey be seen as a not credible witness and therefore you shouldn't listen to anything she says, there would not be an issue at all, I don't think. But that's not what happened here. We had the state, the prosecutors, wanted to have their cake and eat it too. Meaning they wanted to prove that not only was she not being credible, like the only thing she wasn't being credible about was her forgetfulness of her not knowing what happened, because they're saying she actually does know what happened, and what she knows happened is what Meg says happened, because they're on the same page and they're corroborating each other. So they're trying to do both. They're speaking out both sides of their mouth by trying to impeach her, but in a way that's not saying you shouldn't listen to her. It was like selective impeachment. Like you shouldn't listen to her for what she's saying today, but you definitely should listen to her for what she said back during our interview. And that just seems crazy to me. And I don't know why, in what world a judge is going to allow that to happen, at least without a limiting instruction, even though for all the good that would do. But all right, let's move on. The statute requires only that the witness be given an opportunity at some point in the trial to explain or deny the inconsistent statement. So that is what happened here. So once again, this section 770 seems to be properly applied. I will grant that as far as impeachment goes and impeaching a witness's credibility. That seems correct. So section 1235 provides evidence of a statement made by a witness. Let's go through slow. Evidence of a statement made by a witness is not made inadmissible by the hearsay rule if the statement is inconsistent with his testimony at the hearing and is offered in compliance with 770. So it was compliant with 770. So now we're getting into, was it truly inconsistent? Was the testimony at trial inconsistent with the statement beforehand? Let's read it one more time, just to make sure we're getting it right, because sometimes these rules can be worded kind of weirdly. Evidence of a statement made by a witness is not made inadmissible by the hearsay rule, is inconsistent with testimony at the hearing. So evidence of a statement, not just the statement itself, but the evidence of the statement. In this case, that being the video. So, okay, where the out-of-court statement is inconsistent with the witness's trial testimony, the jury may consider the prior statement for its truth as well as for the light it sheds on the witness's lack of credibility. Now that seems crazy to me. And we're quoting here an authority, Calcrim number 318, which I have pulled up, saying, yes, prior statements as evidence. You have heard evidence of a statement that a witness made before the trial. If you decide that the witness made those statements, you may use those statements in two ways. One, to evaluate whether the witness's testimony in court is believable. That's the impeachment part. And two, as evidence that information in those earlier statements is true. So this is a jury instruction here. Basically, yeah, so I won't deny this is what the jury instruction is in fact saying. So the question is, does any of this violate the confrontation clause? Because we're still not actually getting any analysis on the confrontation clause, which maybe we're not going to, because when you look back at the beginning of this intro, right out the gate, they're saying this isn't a confrontation issue. This is just an evidence issue. So here's the problem. Everything that they do here as far as the admissibility of evidence and whether it's consistent with the rules of evidence, this all very well could be sound. And yes, they do have a jury instruction that does point to this being a sound principle. And certainly there are areas where this can apply and be constitutional. The question is, does this application, even if it is consistent with the rules of evidence, does it violate the Constitution? And to that question, they're not addressing that question, which to me, I think either it shows that they were scared to address it, or they just don't understand it properly, which is crazy to say, because we're talking about an appellate court in California, which is a very large state. I have no doubt these are smart judges, but judges do get it wrong. And so, because here's the thing, here's the structure. The Constitution, there's a clause in it called the Supremacy Clause. It holds that the Constitution is the highest, it is the supreme law of the land. It is the top of everything. With the Constitution being the top, being the supreme law of the land, federal law is only legal so long as it is consistent with the Constitution. And the application of federal law is only legal so long as it's consistent with the Constitution. And so what we have here, we're dealing with the rules of evidence. Federal law or state law. So these are state rules of evidence for California. And these rules of evidence can only be upheld in their application if they are determined that they do not violate the Constitution. Because in a conflict between, if you've got a conflict between a state law and the Constitution, well, guess what? The Constitution is going to win because it is the supreme law of the land. Especially, we're talking about an amendment here, an amendment to the Constitution. So it is part of the Constitution itself. It is the highest authority we have in this country. So even if you have sound logical analysis of the rules of evidence and the application of the rules of evidence, you have to analyze whether or not that still violates the Constitution. And you can see they're not doing that here. So, let's see. Well, we got a little bit to go, but let's see. We don't have much further. So the prior statement has a dual purpose. It may be considered for impeachment as well as substantive evidence. And this is the part I just have to hardcore disagree with as far as when you think about the confrontation clause, because how in the world is this consistent with confrontation? And I'm about to do the whole breakdown. Let's do this first. Let me finish reading this, and then I will explain to you exactly how this entire section is still violating the confrontation clause. All right, when a trial court concludes on substantial evidence that a witness's professed lapses of memory are false, evasive devices to avoid truthful answers, it may admit as inconsistent the witness's prior statements describing events the witness now claims to have forgotten. So this is the court saying that they're saying, we think Kelsey is lying on the stand. We think she is, these are professed lapses, meaning they're not real. They're just her stating she has these lapses. But those are false. They are false, evasive devices to avoid truthful answers. So they're openly saying here that they think Kelsey was lying on the stand and she was being truthful during her interview, which is why they're allowing it to come in, because they wanted her truthful testimony to come in because it's helpful for the trial. I get why they would say that, but you have to contend with whether or not this violates Tory's right to confront and cross-examine Kelsey, and specifically Kelsey's statement. So with that said, let's get, I like I said as well, the dual purpose, I just disagree with. I think the impeachment point is fine, but the substantive evidence is not fine, because impeachment purely goes to credibility of a witness and whether or not you should listen to them and what they're saying. Substantive goes towards the actual facts of the case and like, did this person commit this crime that we're saying they committed? So, all right, confrontation clause. Let's break it down real quick. Oh gosh, 50 minutes. Sorry. But this is good stuff. I hope you guys are getting good stuff out of this. If you are, of course, you know the deal. Like, subscribe. We're almost at 2,000 subscribers. This video might actually get us there. So, if you've made it this far, boom, hit that subscribe button. Let's get to 2,000. But all right, Sixth Amendment. This is coming from Congress.gov. So this is not some crack resource. The Sixth Amendment, verbatim. Let's read it. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him. Okay, that's our key part. To have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So a lot of good stuff, a lot of really important constitutional principles between the right to a speedy and public trial, right to a trial by jury, the right to have counsel, the right to confront, due process, the nature and the cause of the accusation. No, sorry, not official due process. That's the Fifth Amendment. But still, to be informed of the nature and cause of the accusation. And then, of course, most importantly, confronted with the witnesses against him. So that's the key part. And we get some analysis here from Congress about what does that actually mean when we talk about confrontation. And we get some documentation of how the Supreme Court ruled on this over the years. So originally, it was Ohio v. Roberts laid out the confrontation clause. That's a mouthful. I'm just going to start saying CC. So Ohio v. Roberts laid out the original CC test, but now the real test, the current test, is now called Crawford. So in 2004, the court in Crawford v. Washington overruled Roberts and introduced a new standard for determining whether an out-of-court statement implicates the CC. Under Crawford, and this is really important, I want everyone to pay really close attention to this. This is good analysis. I'm going to make myself a little bigger too, just because I can. Really important stuff, really deep, really good analysis here. And this is crucial to understanding the case and the argument I'm making as to why Tory's constitutional rights were violated here. So, under Crawford, the key to whether evidence implicates the CC is not its reliability, but rather whether it's testimonial. Very important word here, testimonial. Everyone highlight that, keep it in your mind, we're coming back to it. Pursuant to Crawford, non-testimonial evidence does not implicate the CC. In contrast, testimonial evidence may only be admitted consistently with the CC in limited circumstances. Testimonial evidence may be admitted if the declarant meaning the person who said the statement, in this case, Kelsey. Testimonial evidence may be admitted, before I even get to that, this key here, testimonial versus non-testimonial. They don't actually define it clearly in Crawford, but the progeny, the cases that came after Crawford, do dive into what is testimonial versus not. And the main distinction is, was the statement procured by the prosecutors for the purpose of being used at trial? That's really the main definition, as opposed to non-testimonial, and which are statements that were made outside of court. Remember, all these are out of court statements, which would typically fall under hearsay. So out of court statements, testimonial versus non-testimonial. The non-testimonial statements are statements that are gathered by the police, but not for the primary purpose of a prosecution. So the specific example is if there's an ongoing emergency. Let's say there's a bank robbery. Police have responded. There's someone in the parking lot who saw the robbers running away. Police say, "Where did they go? What were they wearing?" And they say, "They're wearing a black and white striped bank robber suit and a ski mask, and they ran around the corner." And the police go chase, and they find a person who matches the description and arrest them. That statement that person made describing them, that is non-testimonial, because the primary purpose of that statement was to address an ongoing emergency. So that would not be testimonial. Now, let's take the same situation, but instead of the person in the parking lot, now you've got someone across the street who saw the same thing, saw the description, saw them run around the corner. Police have already responded. Police have already apprehended the suspect. The scene is secure now. There is no ongoing emergency. The police now go around and start asking people what they saw. And you get this person across the street who now they say, with no ongoing emergency, they describe the suspect the way they remember the suspect was. We'll say, the black and white striped shirt, ski mask, ran around the corner. And the police are talking to this person, and they're taking their notes and whatnot. That statement, that is now a testimonial statement, because that statement is being procured for use at trial to identify the suspect who they ended up apprehending. And the way this works out in the real world, the police they're completely entitled to gather that statement. And in fact, they should. This is how they conduct their investigations. But the police officer cannot testify at the trial as to what that person told him, because that would violate confrontation clause. No, instead, the person themselves, the person who made that testimonial statement, they have to come to court and they have to testify, which is why they have to, that's the only way to be consistent with the confrontation clause. So I hope that makes sense, the difference between testimonial and non-testimonial, because that is a crucial distinction here. And the key test is, what is the primary purpose? Remember those words too, primary purpose of the statement. If it's to address an ongoing emergency, non-testimonial. If it's to gather a statement that will then be used to assist the prosecution, testimonial. So let's read on. Because remember here, if a statement is testimonial, the rule is that it does not come in. It is excluded from evidence unless that person is there to be able to testify about it and actually testify at trial as to what they would have said on that day or what they remember from that day. Not even that, oh yeah, I said this on that day. They're like, let's say the witness testifies at trial. They would not say, I told the police he was wearing a black and white striped shirt with a ski mask and ran around the corner. They would just testify, I saw him wearing a black and white striped shirt and a ski mask and ran around the corner. So testimonial evidence, the default rule is that it is excluded because it violates the confrontation clause. Right, see? Because we're saying, contrast, testimonial evidence may only be admitted consistently with the CC in limited circumstances. So we have to ask ourselves, what are these limited circumstances? So testimonial evidence may be admitted if the declarant is, one, is available at trial for cross-exam, remember, that's what we keep coming back to, or is unavailable, but the defendant previously had opportunity to cross-examine the declarant about the statement. Those are the only two ways a testimonial statement comes into trial, is if the defendant is able to cross-examine them at the trial, or if they're not available, the defendant had a previous opportunity to cross-examine them. So let's ask ourselves now, let's apply this to the case at hand with Kelsey Harris. First and foremost, was her statement to police testimonial or non-testimonial? Let's ask ourselves. Look, this is like we're in law school. I really hope y'all are appreciating. This is really good informational stuff. But, her statement to the prosecutors. Let's ask ourselves. Let's apply the test. Was the primary purpose of that statement to address an ongoing emergency? Obviously not. The primary purpose of that statement was to gather her story, her testimony, to assist the prosecution at trial. So clearly, this is a testimonial statement that she gave. Like this is one of the easiest examples I could give anybody of what a testimonial statement looks like. So that's the first prong. This is a testimonial statement. So now the second, if it is testimonial, it can only be admitted if one of these two exceptions are met. First off, is the defendant available, or is the declarant available at trial for cross-examination? Was Kelsey available at trial to be cross-examined? No. I mean, she was at the trial. She was available, but was she able to be cross-examined? No, because she wouldn't answer any questions. She just kept saying, I don't know. I don't recall. I plead the fifth. So, so yeah, if you want to call that being available, she was not able to be cross-examined. Alternatively, was she unavailable? Was she so uncooperative that her lack of cooperation by default made her unavailable, which is a way you can determine a witness to be unavailable under the rules of evidence. If they refuse to testify, even if they're present and they're available physically, like you can sit them in the chair. If they just straight up say, I refuse to testify, you can make a finding that they are now unavailable. So let's assume that's the case here. She was so uncooperative that she was unavailable. So if she is unavailable, but the defendant, meaning Tory, previously had opportunity to cross-examine the declarant about the statement meaning the video. So if we're saying Kelsey's unavailable, then the only way her prior statement gets to come in is if Tory previously had an opportunity to cross-examine the declarant about the statement. Let's go back to the case. Let's go back to the opinion. We gotta run down it again. Who was here? Who was present for this testimonial statement? Not Tory. Not Tory's lawyers. So 2 + 2 people equals 4. So clearly, I think by applying the Crawford test, you can clearly see that this is a testimonial statement that Tory did not have the prior opportunity to cross-examine. And in fact, wasn't even sworn. I'm still waiting to see anywhere. I'm trying to skim real quick. I don't see anywhere where it says that her prior statement was a sworn statement under oath. I don't see that anywhere. So that then gets us to kind of this last part, which is, once again, you keep seeing the court talk about a prior inconsistent statement. It should be at the beginning here. As a prior inconsistent statement. So that's the standard they're relying on. So that is a reference to the hearsay rule, of course, which is Rule of Evidence 801. So specifically referring to 801D1, a declarant witness's prior statement, stating that it is not hearsay for a statement to come in when the declarant testifies and is subject to cross-examination about a prior statement. So let's walk through it step by step. The declarant testifies. True. Kelsey is the declarant. She testified, meaning she was sitting on the witness stand. Was she really testifying? Not really. So declarant testifies and is subject to cross-exam about the prior statement. So no, she was not. She was not subject to cross-exam about the prior statement because she refused to answer any questions about the prior statement other than saying she lied during it. So yeah, the only way this exclusion applies, actually, because it's not even a hearsay exception, this is hearsay exclusion, meaning this is stating outright, this is just not hearsay, point blank, period. So her video here was not hearsay, is what this rule is stating. But the only way we can say that is if, she testifies and is subject to cross about the prior statement, and, which we already said that none of that's true, and the statement is inconsistent with the declarant's testimony and was given under the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. So once again, another prong of this, the only way, all of it, by the way, this whole rule has to be true in order for it to apply. If there's one thing that doesn't apply, then you can't apply the entire rule. We've already proven that this first part does not apply. Now it gets to the second part. The only way this comes in, this prior statement, this prior inconsistent statement, only comes in if the prior statement was given under penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. This was not a deposition. This was a voluntary interview that she gave with prosecutors that Tory was not at. So it was not a trial, not a hearing, not a proceeding. So this rule just does not apply, even though the court is saying it applies. So yeah, gosh, all that to say, like, I feel like I'm taking crazy pills trying to explain this. I hope it makes sense. I think it makes sense logically, consistently, and constitutionally above all things. But I know that was a lot of law, and we really got into the weeds on it. But to summarize it all, yes, even if as a court you think that the evidentiary analysis was sound, meaning, right, we've got the two rules here that say, and even here, we've got a jury instruction saying that you can admit this prior statement both for impeachment and for substantive evidence. Yeah, I'm not denying that's what the jury instruction says. But just because the jury instruction says that does not mean it's constitutional in every situation, in every setting. And here, even though, right, the rules of evidence do say that they allow for this, the court still has an obligation to, and we all of us are officers of the court. We swear an oath to the Constitution and to uphold the Constitution above all else. And when you have the application of a state law that, as applied, is inconsistent with a core constitutional principle like the Confrontation Clause, you have to conclude that there was a constitutional violation here. But the court here is escaping that. So I don't want to use the word cowardly, but that's the feeling. That's the feeling I'm getting, because the issue that was raised by Tory's team, they raised the Confrontation Clause specifically. And Crawford v. Washington, remember, we just did the whole breakdown, all these rules here about testimonial versus non-testimonial and whatnot, and the primary purpose test. All of that comes from Crawford v. Washington. So they raised that. Tory's team raises that specific argument, and all they say is, well, he's mistaken. And they don't actually address why he's mistaken. And then they do this whole evidence analysis, which admittedly, yeah, is logically sound. I'm not going to dispute that under the California law. But all of it is inconsistent with the Constitution. And just because you say it doesn't involve the Confrontation Clause does not mean it does not. You actually have to prove how it doesn't involve the Confrontation Clause. Just saying it is so does not make it so. But yeah, I don't know. Like I said, I feel like I'm taking crazy pills, but hopefully this makes sense to everybody. I wish I could explain it in a more concise fashion, because gosh, this video went a lot longer than I expected. But yeah, I mean, I think I'm going to wrap it up with that. Hopefully you guys got some good info out of that. As far as, what all this means, unfortunately, the opinion is what it is. There are opinions that are wrong. Courts get opinions wrong. Gosh, I've had plenty of my own cases where I will still strongly advocate and say that the court got the opinion wrong in some of my cases. But the judge is the judge. They get the final say. They get the call. It's not over yet, certainly, as far as there is still the possibility of the California Supreme Court stepping in, or maybe even the U.S. Supreme Court. Is it likely? Not very much at all. And not just because of the issues here, but just because on a sheer numbers level, they take so few cases every year. Like the Supreme Court, I believe, takes about 180 cases a year out of thousands and thousands and thousands of applications. So it's just a very small number. But doesn't mean to give up hope entirely. It is to mean, though, that we should probably be somewhat measured in how we approach it. But yeah. Beyond that, obviously, I'm aware of the Milagro trial going on this week. Megan suing Milagro, which is related to this case, and whether or not saying that Megan lied during her testimony is defamation. Because if that's the case, I've said that openly, and I will continue to say that. I think Megan was not being truthful during her testimony in the Tory Lanez case, but I've yet to be sued, so I don't know. I guess we'll see. Yeah, it's too bad. It's too bad, but unfortunately, that is it for this case for now. We'll wait to see what comes next, if anything. But for everyone who has come to this channel and has found me through the Tory Lanez case, I just want to say thank you to all of you great people. It's sad that we got to this point, but at least we were able to find each other and build this community together, because it has been a lot of fun and seeing y'all down in the comments. With that said, I am positive this video will invite many haters from Team Meg to come and trash me. I will just point out right now, I'll be down there fighting back person to person, of course. I'll just point out right now, make a bold prediction. Not a single one of them will have anything to say about the 30 minutes I spent talking about the confrontation clause. They're just going to say, haha, you lose, hold this L, loser, without any actual understanding or explanation of why. Like, tell me the why. So I would love to do a live stream where I actually get to debate some of these folks in real time just to expose how ignorant they are. So we'll see. I guess just stay tuned for that. Follow me over on X at the Gen Z Attorney for more details on that. Beyond that, I guess, I got my special announcement to give at this point. Basically, my current job, I'm working at a private firm, but that will not last much longer because I'm going out solo. I'm going to be launching my own firm. It's a big step. It's kind of scary because obviously I got to keep the lights on, keep food on the table, and it's definitely something that needs to be built up over time. But I'm very excited for the journey, for the adventure that is starting next week. With that said, my ability to make videos will probably be greatly diminished because I really need to focus on getting this firm launched properly. But I still will be live streaming. Kind of have two things going on with the channel right now. Two things going on with the channel right now, where I do have the coverage of these types of cases, and I do want to do coverage on the Milagro case because I think that's important to the Tory case. And yeah, it's in trial right now, so I'm sure there will be plenty of analysis to be done with that. So I do want to cover that. That's the one track, is to continue to cover these types of cases. The other track I've been doing is a bit of a legal / political project with some other YouTubers talking about just the American founding philosophy and founding principles about individual rights, the Constitution, stuff like that, and trying to make those ideas cool again as applied to our modern government structure, which certainly does not seem to be very consistent with the American founding. So I know it's a complete left turn from coverage of these types of cases. I don't think I'm going to make videos about that content. It's just going to be the live streams. But just to give you all a heads up, I think it is informative. I would encourage all of you to tune in. We got a podcast every Sunday night that streams here from starting at 8 o'clock Eastern, talking about the issues of the week and trying to frame everything through the Constitution and constitutional principles. And of course, I'm doing debates as well on these types of topics. So I would highly encourage all of you to check all that out, just as far as I think it's important for everyone to be informed. Not necessarily on like politics of the day, but just like, what is America and what does it stand for, and why does it matter that we continue to fight and uphold this country and the principles it was built on. So yeah, there's my shameless self plug for the Ordered Liberty podcast Sunday nights, as well as my good friend Ryan Mullally that I've been working with on that, and the various other folks within that. But yeah, you can follow the channel to get the episodes there. I'm streaming here for now, but posting the uploads of the full episodes after to Ordered Liberty as a YouTube channel. I'll have the link down that in the description here. But yeah, that's kind of it. So if I'm not uploading too many new videos, y'all will know why. It's the holidays and it's the new firm that I'm launching. But I definitely will be back very soon. Like I said, probably the next thing will be this live debate throwdown. Give him all to me. Bring me all the Team Meg, all the haters. Bring them on. I'll take them all down. So yeah, I think I've been rambling long enough. So if you made it this far, shout out to you. Thank you for being here. Go ahead and like, comment, subscribe, all that jazz. I love being down in the comments talking with y'all, of course. Likes help with the algorithm, and subscribing. Like I said, I'm so close to 2,000. This video, depending on how it does, might actually get us there, but only if you guys like and comment and share it to other people that are also Team Tory. So yeah. So y'all know what to do. Let's get to 2,000, and thank you all again for being here, for making it this far, and I will see you all on the next one.